All right, so it's 5 past 6 p.m. and welcome to today's episode of Lawyer's Diary. Today we are coming to have a discussion. The discussion is purely on landlord tenancy rights in Ghana. I know a lot of people have sent me various questions, and most of the questions boil down to the fact that what are the rights that a tenant have even in a tenancy agreement, whether the landlord even has any rights once he gives out his property or lets out his property. And then in an instance where there are no tenancy agreements between the landlord and then the tenant, what are some of the rights that can be accrued from there? And then just in case that there is a legal suit and there's change in ownership of the property, what are some of the things that needs to be done? If you are a tenant, do you need to give up possession to the person who have been declared by the court as the rightful owner? Or you just have to atone tenancy to the new, when I say atone, you have to acknowledge the new person. Yes. And then if there are any outstanding bills that needs to be paid, are you going to pay to the old one who is your rightful landlord because you signed an agreement with them? Or once there has been a change of ownership or the court has kind of changed who actually owns their property, you're also going to change same. So these and many other things that we'll be discussing today. And I must assure you that our resource person today is somebody that I've actually followed for a while, and I know his capabilities. He's a person of Kwabena, Frimpong, Mensah. I have known Kwabena for some time now. During our days at LLB, Kwabena is a junior. He's an associate at Robert Smith Law Group. He concentrates more on civil litigation, sports law, and also acts as company secretary for most of the big companies here in Ghana. So I'm honored to have you, Kwabena, and I look forward to having a very fruitful discussion with you. So we zoom into what the people are willing to hear from you. So Kwabena, welcome to the show.
Thank you, thank you. I'm very honored that I've been worthy enough to be followed. We are slowly getting there. And good evening to your viewers. I'm happy to be with you today so we can have this little discussion and better get to know each person's rights under whichever tenancies we find ourselves in now and in the future.
Sure. So Kwabena, let's move in straight. If I have a property and then I want to give it out to say tenants, what are some of the things that I need to consider in letting out my property?
A tenancy, like every other contract, has basic elements which should be met. Like every contract, there should be an offer, an acceptance, the intention to create a relationship, and of course, consideration. Where consideration is whatever exchange is being done to ensure we both perform our obligations under the tenancy. You must use a landowner in your property, with your property. You're looking to find a tenant who is going to pay rent on time and who's going to observe the various covenants in whichever agreement you enter into. Where we have a system, or by law, every transfer of an interest in immovable property should be in writing.
Most 98% of our listeners are not lawyers.
No problem.
You are mentioning covenant, you are mentioning.
I will break it down as we go.
Break it down.
So, in your agreement, or in whichever agreement, tenancy agreement you are going to make, it should be in writing. That is the basic requirement of the law when it comes to transferring an interest, or in this case, a tenancy. Okay. However, there are some exceptions. For example, where the lease or tenancy is for less than 3 years, the law permits that it does not have to satisfy that writing rule. A lease or an oral lease for a period of less than 3 years, it can just be orally and agreed by the party, and it will be binding on the parties. But it's always convenient and it's safer to have your tenancy in writing.
Okay, so what you are saying is that if I have a house and I'm giving it out to say one person or to a company,
Yeah.
and that, typically in Ghana, most of the tenancy agreements are in 2 years. 2 years,
Yeah.
1 year, 2 years, 1 year.
Some extend, but then the general one, well, it's not necessarily for 2 years. What has become the phenomenon is that landlords are asking for 2 years rent in advance. So
Yes.
everyone is assuming the tenancy is for 2 years.
Okay.
Most of these tenancies have renewal clauses in them. Even if it's not in writing, there's the agreement that after the end of the initial 2 years term, we will renew for another period of time, maybe subject to new terms as agreed between them.
All right, so what you just said before the statement was that if it is for less than 3 years,
yeah, the law allows
for
an oral lease.
An oral. But for oral agreements, there are a whole lot of controversy that surrounds it.
Exactly.
Especially when you don't have witnesses around to confirm what the intentions of the parties as at the time of making it. So how do we confirm that, or what are some of the challenges that people are likely to face if they go strictly by what the provisions of the law say?
The difficulty with oral leases is that should an action commence, it's a matter of he says, she says, especially like you said, when there are no witnesses. The safe option all the time is to have every transaction in writing.
Okay.
In saying that the law allows it, is just to draw your attention to the fact that it's an exception. It's not every transfer of maybe an interest that has to be in writing. For example, if you inherit a house, it's not a direct transaction between two people that is in writing. It is as a result of someone's will. So it was just to show that there are exceptions to that rule. But for every prudent landlord and tenant, it's always better to have your agreement in writing.
Okay, so now that being said, if I am a landlord and I want to put in a written tenancy agreement, what are some of the provisions, what are some of the clauses that I have to bring in my agreement to make it a solid one so that later I won't face any problem with regards to the agreement that I've gone into?
The first requirement of any tenancy agreement is the names of the parties. You normally find it in the part of the agreement known as the recital. It is very important to detail who exactly is entering into the agreement. The agreement should be between Onesimus Osei on one side and Kwabena Frimpong Mensah on one side, properly described, so there's no controversy later on in life. The next one is a proper description of the property being rented.
Before you go to the proper description, in terms of the names, if I'm dealing with a company,
yes,
who is the proper party to sign off on behalf of the company? Can any employee of the company sign? Is it just the directors, or have to insist that the CEO signs?
Companies by law operate by officers. Well, the officers or the first officers are normally the directors of the company. So you would find that in any agreement being entered into by a company, it is always the directors or a member of the board, or in some specialized institutions. So, for example, if it were a bank that we're entering into a tenancy agreement, you would see it's the estate manager of the bank that enters.
Okay.
A properly appointed officer to enter into such transactions on behalf of the company. So you will find that in such an agreement, you see the recital stating duly authorized officer or duly authorized employee of the company, and you'd see his or her name there and maybe portfolio. You know that it is binding on the company. So the company is bound by the acts of its agents.
So in an instance where, say, any of the officers of the company signs,
Yes.
the person is not a director, the person is not the CEO, or have not been sanctioned by the company, but then the company continues to pay off the rent, would that action be deemed as authorizing such transactions, even though they haven't really sanctioned the person to?
Should it go to court, or should it be a matter of proof? The company would be stopped from relinquishing any liabilities under the said tenancy.
Well, they're stopped.
I will break it down, don't worry.
Right.
What that means is that the company is bound by its previous actions by undertaking all the obligations under the tenancy by paying rent. And that is one of the most important obligations under a tenancy agreement, the payment of rent. Where you are paying rent, you are keeping the property in a repairable state, you are not subletting without the landlord's consent. When it's time for renewal, you exercise that renewal clause. You are abiding by all the obligations in the tenancy. You cannot then state that because the person who entered it on your behalf was not authorized, you are resiling yourself from it, and you do not want to bear any liability or anything done to them. So that's what stop all means in simple terms. You are bound by the things you have done.
Okay, so after the parties have been properly described, what happens again? You were talking about properly describing the property.
Describing the property. I've given an adequate description of the property. If it is a room that is being rented, you state it, the room inside this house. If it's a commercial property where the rental is done in terms of square meters and by dimensions, you can describe it. Maybe block A of this building, the space measuring maybe 100 square meters, so that there's no doubt as to what was the intent of the parties. The next part is the rent payable and the payment plan, or how the payments are to be scheduled. Normally, you'd have rent to be paid monthly. The law allows for the payment of up to 6 months in advance payments, but nothing more than that.
That's a serious issue that we need to discuss.
We will get to it. So
all
then,
right.
Your agreement should also contain the rent paying and the manner in which it's to be paid. After you have established that, then the rights of the landlord and the tenant under the agreement. Each party has a certain role to play. The landlord has
we'll come to the rights and then the liabilities. But you mentioned something about 6 months rental payments.
Yes.
Is that what the law states, that once I'm entering into any tenancy agreement, I should not pay more than 6 months, or I can pay minimum of 6 months?
So I think at this point in time, I would have to refer your listeners to the provisions of the Rent Act.
Okay.
So the Rent Act, Act 220, in section 25(5), is explicit in the number of months. Yes, very, very clear in the number of months advance payments you can make. And it is not to exceed 6 months. So where you have landlords claiming 2 years in advance, a year in advance, a year and a half in advance, it's in breach of the provisions of the Rent Act. The problem has become enforcement. A lot of people do not know their rights as tenants and where they can seek redress in such an instance. But I believe as the conversation continues, we will get there, so people are more abreast of what they can do and what their rights are as tenants. Not even tenants, as prospective tenants, because the Rent Act doesn't cover just existing landlords and tenants, but also gives some recourse to prospective tenants.
All right, I'm still coming back to the 6 months because it's something which clearly has been a headache of every prospective tenant, and then even if you are a tenant and you intend to renew your tenancies after it is expired.
Yes.
Assuming I come to Kwabena Frimpong, Kwabena has a 3-bedroom apartment, I want one. I tell Kwabena, I need it for 6 months. I need it for 2 years. If the law only allows you to take a rent payment of 6 months, it means that you can't even give me a tenancy agreement for more than 6 months, because that would be in breach. Is that not the case?
That's not the intent. Now, the tenancy may be for whatever period. However, what is limited to the 6 months is the
rental payment.
The rental payment. You cannot claim more than 6 months at a time. What we have termed the rent advance. So it is the rent advance that should not exceed the 6 months period. So
if my landlord tells me that I am not accepting the 6 months, either you give me 2 years or I'm not giving the property to you for lease or rental, what can I do? Practically.
Practically. That's so
practically, yes.
Practically.
So legally and practically.
Legally. Let's do it legally.
Let's do it
legally. Now, legally, every district has what we call a principal rent officer. So I would like to use where I live, the district I live in. There's a principal rent officer for Ladade Kutupong. By law, the principal rent officer is to have a registry of all landlords within Ladade Kutupong. And he should also keep a registry of all unoccupied premises which are for rent within the district. That is what the provisions of the Rent Act allows for with respect to the functions of a principal rent officer. Now, in this part, I am an interested party.
Okay.
By law, I can go to my principal rent officer for the district to which I live in, and then report to the principal rent officer, who then, with the powers vested in him, would try and settle it by not only even when it comes to the quantum of rent, the amount I should pay as rent, the principal rent officer by law is given power to do an assessment of how much rent I'm supposed to pay for that property. That is legal.
That is a legal.
That's a legal aspect. Now, practically, unfortunately, tenants are at the mercy of landlords. It's either you are kowtowing to the landlord's demands, or you are not getting a place to put your head. There's been much talk about reforming our Rent Act in its current form to make it more proactive, or to make sure these provisions.
We'll talk about the practical reforms that we can all contribute in terms of reforming or reshaping the rental situation in Ghana. But I mean, what do you think that the landlord or the tenant has any rights after paying for his rentals in the house? Because practically sometimes some people have complained that they'll be in their house and the landlord will just bump in. The right of privacy. What are some of the rights that once you give me your property, aside you giving me the peaceful enjoyment of my premises, what other rights can I enjoy as a tenant?
We've moved into the rights, even though we're still the basic right of every tenant is, pardon me if I use this quite technical word, but the basic right of every tenant is to enjoy quiet, peaceful enjoyment of the property you have rented, where peaceful enjoyment means no interference in the use of the property from your landlord. Once you have satisfied the condition of paying rent, entering into the agreement, paying your rent, entering into possession of the premises, you are entitled to peaceful enjoyment of it, free from any interference from your landlord. Your tenancy agreement would have created a clause for the giving of notices, where a notice is anything that has to be said in relation to the tenancy. So if my landlord wants to inform me that he's coming to do construction works on the outer perimeter, because it's one of his rights also to make sure the premises, the outside of it, is fit for the purpose for which it is rented. There's a way of which he can give me the notice. He doesn't have to barge into my room as it is at that moment. That is interfering with my peaceful enjoyment of the property. So that is the basic right of every tenant. Peaceful enjoyment of whatever premises you have rented.
Okay. Aside the peaceful enjoyment, are there any rights that the tenants can enjoy?
Yes, so then the premises should come with utilities, because the tenant is responsible for paying the utilities, electricity, water, in some tenancies, access to phone lines, as was prevalent previously, sewage collection, all of those things the landlord must ensure his tenant has access to. The tenant is not to pay things like land taxes and property rates.
The statutory payments.
Statutory payments. All statutory payments are to be made by a landlord.
Okay.
So
okay.
For every tenant out there, just know that those payments are not to be borne by you. This is subject, however, to whichever agreements you have with your landlord. If you willingly enter into such an agreement, you are bound by what you signed to.
Okay. So it means that what you your last statement said, you are bound by whatever you
signed to. Yeah.
But practically, you can't also assign any rights out of statutes. It has to be in line with
the statute.
What if in my agreement with my landlord, I don't know, and it makes me understand that if they are taking any statutory taxes like the land taxes, property rates, I have to be the person signing and then paying, and then I sign it. So that mean that once I've signed it, I still have to pay?
In such a situation, like I said earlier, you are bound by what you signed to. The good thing is that in our laws, in the Conveyancing Act, the Act allows for certain implied covenants. So even though stated or non-stated, they are implied by the operation of common law. I'm sorry if we are going into this, but then those covenants or those rights, even though not stated or may have been stated, they are implied. So the landlord in himself knows that these things are to be paid by you. In fact, such bills, if I remember correctly, I even the names of the landlord on the property. So it would be very difficult to come and impose such a bill on me as a tenant.
All right. You also talk about the landlord allowing the tenant to have peaceful and quiet enjoyment of the premises. Now, the practical example, which I will need your opinion on, is that somebody rented a five-bedroom apartment. So they were in one 3-bedroom and then the other 2-bedroom. So in between the two, there was a large space, which is more like a playground. Now, the landlord later came back and said that she wants to use that as, every Saturday, those football they show the super sports on television and take money for people. So she wants to use that space for that project. If I'm a tenant, that is one way or the other infringing upon my peaceful enjoyment in the premises, especially when matches can go for the Spanish La Liga sometimes 8, 9, 10 p.m. and people will still be shouting in my premises. In that instance, can I prevent the landlord from using that space for that purpose? And how do I?
Yes, you can. So it goes back to one of my earlier statements. In entering a tenancy, you do have to properly describe whatever you're going into. And when you're describing, if it's a house, you are describing everything that's the land that the house is on and everything surrounding it, unless a contrary intention is stated. So if you have rented this 5-bedroom house and all that is in, your landlord then coming to, as it were, host football matches in that walkway is interfering with your rights, and you can object to it. In fact, you actually should object to it. It is not something you should allow, because it's infringing on your.
Because according to the landlord, to her, he just rented the premises to you, and it doesn't include open space which she can at any point come into use.
In defining the premises, even by our laws, it includes the spaces around it. It's not limited to, like I said, if you're renting just a room, then your quiet enjoyment is limited to your room.
So it doesn't mean that the landlord can bring speakers outside my room and then just be bashing because my enjoyment is
your quiet. It involves your peaceful enjoyment. So peacefully enjoying what you have paid for. Now, the noise of the speakers is a nuisance, and it's interfering with your enjoyment. The sound waves don't bounce off your wall and not enter the room.
Yeah,
they do. So it's an interference with your enjoyment.
Okay.
So once you have your tenancy agreement with your landlord and you have signed against and you've moved, anything the landlord does which interferes with you enjoying what you have paid for is in breach of your tenancy agreement.
All right. Thank you very much. We'll come to the next phase of the presentation, which will discuss if there are any changes in ownership through a court order, what are some of the things that we need to consider, and that if I want to evict my tenant and then the tenancy hasn't really expired, can I do that as a landlord? How many, in terms of notices, what is the reasonable time that I need to give to the tenant? And in an instance where the tenancy has expired and the tenant is still being champiata in my room, what are some of the things that I need to do? This program is called the Lawyer's Diary. What we do is that week in, week out, we discuss general topics ranging from corporate, commercial, family, and any other thing that you can think of. You can follow us on Facebook as the Lawyer's Diary. Instagram is the Lawyer's Diary Global. YouTube is the Lawyer's Diary. Subscribe to our pages, and then you can always also get updates on whatever we intend to bring up. I'll display our banner so you can see what we are doing. Today's episode is sponsored by Enos Travel. Dennis and Martin, if you are here, we can give you just 3 minutes. Speak briefly about Enos Travel before we move to the next section. Dennis?
Yes, lawyer, I'm here. All right, so as lawyer said, Enos Travels is one of Ghana's best travel agencies that you can find. We assist people in getting visas. We assist students who also want to travel, go abroad and actually have higher educational standards. And then also, we also help people that want to seek employment in Europe, in Asia, in America, and then in Canada. And then because of the COVID, we usually organize tours to Europe, to America, and then to Asia. But then this year, all the tours have been canceled. We are currently planning another tour because now it is safe for travels again, of which most countries have opened their borders, including Ghana. And then, for example, the UK has opened their country to all services. I mean, if you want to go on a tour in UK, you can go, you can apply for the visa at the UK High Commission in Ghana. UK is one of the countries that have opened for all services for after the COVID-19. So we are open for business. You can find us on Facebook at Enos Travels. You can find us on Instagram, eno.travels. And then you can also find us on Twitter, travels.eno. So if you have any traveling issue, if you want to go on a tour, if for the students who want to have their master's or their PhD programs either in the US, in Canada, or in Europe, and then for the business people who want to travel to meet other business partners, and then people also who have friends and families outside who want to visit them, and then also who want to join their families, either if you have a husband or a wife in the United States, in Europe, or you have a mother or a dependent in Europe, if you want to join them, you can contact Enos Travels and we will bring you to the destination you desire. Enos Travels, taking you to the world and beyond. Thank you very much, Lawyer.
All right, so we are back. Lawyer Kobe, that was Enos Travel, taking you to the world and beyond. They are our proud sponsors for today. I hope you can hear me.
Yes, I can hear you.
So we'll go straight into our second phase of the discussion. If there happens to be a change in ownership, whether through a court order, by successful litigation by another party, or through when the owner dies, there being a will which is read, probate has been granted, and then is being assigned to a particular person. What happens if I'm a tenant? What should I do?
So if it's by a court order and you're a tenant, let's say your landlord has been adjudged to not be the owner anymore, your tenancy does not expire then you may atone tenancy to your new owner. You basically state, you have copies of your agreement, you are in possession. You have your new tenant, new landlord, maybe it is Mr. Latte. So Mr. Latte, this is the existing tenancy I have with Mr. Osei. By court, Mr. Osei is no longer owner. So here it's my tenancy, here's the term I have left unexpired with my tenancy. These are the conditions under which I was put into the property, the terms under which I was put into the property. So as new landlord, I want to atone tenancy to you. Because you can't, even if it's a court order.
When you say atone, do you mean acknowledge him as your new
acknowledge him as your acknowledge him as your landlord. If it's a monthly tenancy, now you know where your payments are going. Your payments are no longer going to Mr. Osei, they are going to Mr. Latte, who is now my landlord. Now, even if it is a court order, a lot of tenants fear that when this is a court order, he no longer has possession, I'm going to be thrown out. In executing the order, the person has to apply for what we call a writ of possession. And every writ of possession is on notice to whoever is in actual possession of the premises. So you clear with the process. You have the opportunity to present your case before the court and state that I am in possession by virtue of this tenancy. In the circumstance, you can't just throw me out. The person can just throw you out without also putting you before the court for you to present your case, for lack of a better word, fully to the court, and the court will make such orders as it deems fit, taking into consideration the circumstances of every case.
Okay. So in an instance where pending the final determination, there are controversies as to who owns the property. A typical example is that here in Accra, some tenancy agreements are done monthly, so that at the end of every month, the proposed landlord goes in and then takes it. Now, the man dies, pending either an LEA to be given by the court or probably to be granted. 3 of the kids are now claiming to be the proper owners of the premises. If it's a monthly by month tenancy, who do I pay the rent to?
This is actually a common situation that happens to a lot of people. I'll take it to in the various ways you put it. Should it be death of your landlord? When your landlord dies, his estate probate or letters of administration has to be given in respect of his estate. After that, the property itself has to be vested in whoever inherits it, be it a son, a daughter, even his wife. Till that is done, who do you pay your rent to? Especially, you want to avoid a situation where you pay to the wrong person and then
double payment.
Nobody wants to. So while you are waiting for that, prudently, it also becomes a means for people to squander the money. Put it in an account. Let it build some interest. At every point, you are notifying whoever your landlord is. This is practically, it accrues some interest. The time all that is settled, probate has been granted, the vesting has been done. You have a new landlord. Then you can make your payment to your new landlord. There are 2 people. Of course, that is the reality is different.
Yes, I agree.
The reality is different because you can only be hounded by some people for so long.
Yeah.
You are still enjoying.
Before you get to your room, you see people
standing by the door,
their rent
coming for their money. But then that is the safest option, because I don't think anybody wants to be in a situation where he's doling out money every month to a different person. That's the safest option. Especially with the way litigation goes here. Litigation can be going on for years. There are some tenancies, people enter into tenancies, and the condition for entering into the tenancy is that you even sponsor the litigation. If I win, whatever you use as sponsorship will be to set your rent.
It's true.
So it happens. It's a very real life situation. But that is the safest. You can put it in an escrow with all of them as parties. The money is only released on consent of each person. That is practical. So they know that your money is there. Your money is in account. It's an escrow account. It will accrue some interest. So it's not sitting there growing dust and becoming wasteful. As soon as your litigation is over, your dispute is settled, I pay whoever my landlord is. That's practical.
That's practical. Okay. So that being said, let's now come back to the closing chapters of our discussion. If I want to terminate an agreement I have with a tenant, in terms of notices to them, what is reasonable notice?
Reasonable notice is dependent on the circumstances of each case.
Yeah.
Now, normally your tenancy agreement will have a termination and renewal clause. It will state the duration for the tenancy and the duration for giving notices with respect to termination and renewal. Most tenancies will give you maybe a 3-month notice period where you have to provide notice of either termination or renewal 3 months before the tenancy expires. Under the Rent Act, where a landlord wants to terminate or wants to recover possession of his property because he wants to either acquired for his personal use, wants to remodel it, wants to, it's quite common now, break it down and enter into maybe a joint venture to build luxurious apartments.
Yeah.
He's mandated to give you at least 6 months notice of the intention to recover or to apply for a court order for recovery of possession. So in such a circumstance, 6 months is what is the law deems reasonable. Your tenancy may have 3 months, and like I said, you are bound by what you signed to. So if the person gives you the requisite notice under your termination clause, 3 months, I have given you 3 months, I intend on taking back my property. I want to occupy it myself. I want to give it to my son, my wife. I have employed somebody, and in the course of my employing the person, I need to find accommodation for the person. Yeah, he will serve you the requisite notice. And as a tenant, you also start your search for a new premises.
Okay, so let's take it that the 3 months notice is what is required. I mean, reasonable notice. If after the 3 months the tenant says that I'm not leaving, can they still continue to stay for some minimum number of months without paying for any rent, or I can now go to court and I get them off my premises immediately?
Once there's a breach of any of the covenants in your
any of the terms,
as a landlord, you're entitled to certain remedies. Where remedies is reliefs. One is an action for ejection and recovery of possession, which is made before a district magistrate or a rent magistrate. Only rent magistrates can make such an order. You have the right of re-entry and forfeiture. To forfeit, but the right of re-entry, the right of forfeiture accrues when there's a breach of a term, and the lessee or the tenant has been given notice of the breach of the term within a reasonable time, and the tenant still refuses to remedy that breach. Then, by law, the landlord may exercise his right of re-entry into his property.
But how do we re-enter? So, like practically, you're supposed to give me, say, 500 cedis every month. It's, let's say, a monthly tenancy.
Yes.
And this month you fail to pay. I've notified you. You know that at the end of August 2020, that was the end of your tenancy. September, you are still in. Why should we even go to court? Because ideally, you know that you don't have any right in my premises or my property. And is it a case that I need a court order before I can evict my tenant?
Before you can make it.
And if they fail to move out after various notices, can't I bring my own people before they come? In Kumasi, sometime before you come to the house, they've taken the roof off. And so
well, it is a crime, for lack of a better word, to induce a tenant to quit. It's part of the offenses that form part.
It's not inducement. I need my property, especially when you don't have any rights in my property, because you've breached a very salient covenant or term in the agreement which requires you to pay me my rent. You haven't paid. I've given you notice. The notice has still gone by. I need my premises. What do I do?
Normally, what you said, as with the lifting of roofs and other underhand tactics to get a tenant out, is what is done. But the Act provides that even where the breach is that of rent, where rent has remained unpaid for even a month after it becomes due, you go to the rent magistrate and then apply for the order. Because even with forfeiture, tenants are giving what we call a relief from forfeiture. where when you begin, the tenant may seek an action stating, yes, the remedy is yet to be, the breach is yet to be remedied, but I can, due to the circumstances of my case, I cannot move out at such a point in time. And the court, on hearing this, may make such orders as they deem fit. The orders will include award of costs, damages, any monetary compensation, in addition to the arrears of rent owed, a stay of the forfeiture.
Practically, the person is not giving you money. If
already the person isn't giving you money.
Yes.
But then we live in a society run by laws, and everything done should be within the ambit of the law.
Okay.
What you may deem to be an exercise of your right as a landlord may also have criminal undertones. You beat a tenant because he owes rent. It's assault. It's battery. It's criminal. You may face a criminal prosecution because of that. You cause harm. Unlawful harm is a crime. The apprehension of fear. So, in one breath, you are exercising your rights legally as a tenant, but your acts may have or may avail to some criminal liability. So, let the court take its course safely.
Okay, I've also heard a lot about some concepts called statutory tenants. When we say statutory tenant, who is a statutory tenant and what are the rights of such a statutory tenant?
So a statutory tenant is a tenant who stays in possession of your property after the expiration of the tenancy due to some protection afforded by the Rent Act or any acts of similar nature which was enforced before the passing of the Rent Act, or a subtenant, where a subtenant means after the initial tenancy, the tenant rents out to a different person.
How can a tenant rent out? Okay, we'll come. That's also a topic that we need to clarify before you go.
A subtenant may also become a statutory tenant, where an order of ejection has been made against his sublessor, the tenant who leased it out to him. An order of ejection has been made against him, but the subtenant is in possession. The subtenant cannot be ejected by the ejection given to the original tenant. So the subtenant then becomes a statutory tenant because it is afforded that protection by virtue of Section 17(5) of the Rent Act.
Okay, no, break it down for us.
So the tenancy is between Mr. Mensah and Mr. Osei.
Yes.
Mr. Osei is the tenant.
Yes.
Mr. Osei, the tenant, subsequently rents out that same property to Mr. Latte. Mr. Latte now becomes the subtenant.
But can I, a tenant, also rent out the remainder of my interest in the agreement to a third party? And even if so, don't I need the consent of my landlord?
So an arrangement to sublease or to rent to another person must at all times be with the consent of the landlord. It's one of the covenants, one of the obligations of every tenancy, that you, the tenant, will not assign, sublease, or in any other way dispose of the interest you have got in the premises without the consent of the landlord. And this consent should not be unreasonably withheld. That is the remit of the law. That if as a tenant I want to sublet it to somebody else, I must seek your consent. And so the subtenant will pay rent to me, the tenant, and me, the tenant, I will pay rent to you, my landlord. Okay. Where the tenant fails to pay rent and I get an order of ejection against the tenant, the subtenant, the order of ejection does not operate or does not work on the subtenant. And so the subtenant will continue to stay in my house as a statutory tenant. Statutory tenants have certain rights.
Somebody who is a
The
statutory
person
tenant
is
has
led
rights.
by the operation of the law. So the law
Okay.
also affords him some rights. The first of these rights is the right to pay rent. So a subtenant or a statutory tenant, must pay rent every month. Statutory tenants are tenancies held monthly. So he must pay rent. That is the first. The second is that he is bound by the terms and conditions on which he was let into the premises.
But practically, the statutory tenant may not have even been seen by the landlord, because ideally, if say it's a third-party transaction between the tenants who lease it out to a third person without the consent of the landlord, I don't know you. How then do I even accept your rent?
Yeah, I believe the intendment of the law was the balancing act of each person, because let's not forget that the subtenant has also paid rent to somebody, and so he has paid for what he is enjoying now.
Okay.
There exists no, I'm sorry I have to use this word again, privity of contract.
Which means
the contract relationship and the contract terms between the landlord and the original tenant are not binding on the subtenant. The subtenant has privity of contract with the person he contracted with. So the balancing act of displacing somebody who has paid valuable or has made valuable consideration to enjoy the premises, to keep him there as a statutory tenant. That is the protection the law affords such a subtenant. That's why they are statutory tenants. They are there by a creation of statute. It is the law that keeps them there. The moment that law is abrogated or repealed, their status becomes
okay.
The last right, I think this is also important. The last right statutory tenants have is that the statutory tenancy is determinable at their own rate. Because it's a tenancy that exists from month to month, on giving the 1 month's notice, they may terminate the statutory tenancy. But till they do, they will continue to pay their rent to you at the end of every month. They will continue to abide by the covenants of the tenancy agreement, even though it is no longer in force. A statutory tenancy also dies with the tenant. It is not one that can be passed on. So in this scenario where Mr. Latte is a statutory tenant, the moment Mr. Latte is called to glory, that tenancy ends. He cannot pass it on to his heirs. He cannot will the property to his successors. It is one that
because practically he himself doesn't have any rights.
Exactly. He's just there because the law is protecting him and keeping him there. The moment he dies, that protection does not extend to his heirs.
Okay. Now let's clarify this for me before we ask for the questions from our audience. You know, sometimes there's a specific purpose for which I rent an apartment, but in the course of my stay, I may want to change from, say, residential to commercial. What happens if the landlord later finds out that the purpose for which I rented the premises, I've stayed there for some time, I've realized that, oh, okay, this place, if you do a small store in front of this house, so I start selling. I may have even erected a small structure without informing the landlord. What happens if the landlord later finds out that this is what happened?
It forms a breach of the tenancy agreement. Now, even though it may not be stated explicitly in your tenancy agreement, statutes allow certain covenants to be implied, where one is that you will not make considerate or considerable amendments or, sorry, not amendments, alterations to the structure of the building without the consent of the landlord. So if you rented a 2-bedroom apartment as a dwelling place, you cannot on your own surreptitiously then break walls and turn it into an office complex without the consent and without the notice of your landlord. It's a sufficient breach, and it entitles him to terminate the contract or even ask you to be ejected. In dealing with people's property, the paramount thing will always be, for every alteration you want to make, it must be with the consent of the landlord.
Okay. Thank you very much, Frimpong. I'm really impressed of the submissions you made, and I've personally learned a lot. And this was more or less like a revision for some of us who've been taking a long time to revise some notes. We'll throw it out to the public. Yes, if anyone has any question, the person can unmute himself or herself and then ask the questions for us to answer you. I saw one hand up, Louisa Ofori. Louisa, please go ahead and ask your question.
Hi, good evening. I'm sorry I can't show my face.
No, so that's fine.
Right. So I'm going to create a scenario so that the question will be in there.
All right.
Now, there are 2 tenants, right? Tenant A and tenant B, and then a landlord. Now, tenant A occupied a single room, self-contained, and for I think 6 months, and she decided not to continue renting. So she told the landlady that, oh, I want to leave. The landlady said, okay, if you want to leave, but then she had paid for a year. The landlady said, if you want to leave, bring in another person who would like to occupy this room, so that the person pays your 1 year rent advance that you pay to you. And she agreed and brought in another person. That's tenant B. Now, tenant B came and paid an amount. She decided to stay for 2 years, and she decided to pay the 1 year rent to tenant A, and then the rest to the landlady. And in the course of her stay, she decided to put tiles on the floor, and change certain things, window frame, among other things. But she sought the consent of the landlady. And the landlady said, oh, you can do that, but it would not be at my cost. You are doing it for your own comfort. So yes, if you want to do tiles, go ahead. So tenant B went ahead, did all that she wanted to do, a lot of fixtures. And she stayed for about 2 years and some months. Now the landlady was also in a tight situation, and she needed to move into that one room self-contained. So she gave the tenant B 6 months notice that, oh, due to so and so circumstance, I need you to move. So you should start looking for a place. That's what I've told you earlier. Now, within, I think around August last month, tenant B says the landlady a document from rent control that she's demanding a sum of 5,700 for the tiles that she put in the room, amongst the other works that she did, because she's being induced to leave. Now, before all this, there was no tenancy agreement. Everything was verbal, based on trust. Oh, I know you, so, you can go ahead and occupy the place and all that. Will the tenant B succeed in this serve that she has served the landlady? Thank you, I'm done.
Very interesting.
Very interesting question.
Very interesting question.
So it's basically tenant B now against the landlord.
Yes.
So as already stated, whenever you're making any changes to the property, it should be with the consent of the landlord. most of the time, the landlord is supposed to make the premises fit for the purpose for which it is being rented out. So you will find situations where people make alterations and then they agree between them that it is used to set off against their rent. It's something that happens. Now, in this situation where every alteration done was done with the tenants, with the landlord's consent, and the tenant also consented to do it at her own cost. She did not ask that it be offset against her rent. She did not ask for a refund. If, of course, I'm sure if she had asked for a refund, then the landlord would have elected to do it herself, and then know that she's done these improvements at her own cost, and it may affect whatever rates of rent she wants to receive the next because she's made sufficient improvements. Of course, when they are assessing rent, the principal rent officer has to take all of these into consideration. The situation you have, none of that was done. A tenancy, as you have said, has expired because it was for a period of 2 years. You didn't make mention of any renewal. Hello?
Yes, we are
Hello,
listening.
yes. So she intended to renew it. And I'm sorry, I should have added that she asked that some part of the cost be offset by her rent. So you
was
know,
that done?
the landlady agreed that okay, then you can use that to offset some of your rent.
So then the offset was done.
It was done.
That is the challenge. The challenge will then be that because nothing is expressly written, the landlord can later then come and say that ideally that wasn't part of my premises. I don't even remember consenting to it. You may have told me, and then you just wanted to adjust the premises to fit how you want it to be per your standard. And then once, you haven't. We didn't put anything down consenting that it can be offset. It becomes a bit of a problem.
Well, what she is stating is that the offset was actually done. So she has more or less paid for all the alterations that were done. The window pane, was it windows or curtains that were installed? The
window frame, tiles, little things.
So if all of these little things, as you say, have been already offset and deducted from her rent, then I find it hard to find where her claim would be. Because the thing with fixtures and tenancies is that normally fixtures are immovable property, things you can easily pick and take away. If I put up maybe an electric lamp in the premises, it's something I can pick up when I'm leaving. My tenancy has expired.
What do you say to tie a day? My smile.
Please go ahead.
So the fixtures are normally things I can pick and take away with me. A little lamp. Maybe I installed a camera at the entrance. When my tenancy is over, I'm giving you back the premises in the state in which it was given to me. We have some tenancies that have maybe security deposits, where if there's any damage done to the premises during your tenure, if your security deposit is what is used for making the repairs. Now, in this case, her repairs or her fixtures or anything she did for the property has been paid for because, as you said, it has been offset.
Hello? Hello?
Hello?
Can you hear him?
No, I cannot. I cannot hear him.
I'm sure
his network
will come back. But practically, the issue would be that if the person is unable to prove that the landlady consented, then it will be practically difficult for her to now assume or claim any monies arising out of any alterations that you've done.
Okay.
Yes.
And she also said she was being induced Meanwhile, she was given 6 months notice.
Yes.
Even I think it was even more than 6 months. It was
I agree.
like
So
7 or 8 months notice.
Yes, the point is that tenancies are for specific period. I'm giving my house to you for a period of 2 years. I'm giving my house to you for a period of 1 year. At the end of the tenancy, there's always a clause that parties may renew. It doesn't say parties shall renew.
And it is
So
at the
may therefore
discretion.
means that I can give you notice 3 months before the tenancy ends and then get you out of my premises. By the time it's
not to cut you short, but in every tenancy agreement, there's always a clause that states that at the end of the tenancy, the tenant will deliver vacant possession of the premises to the landlord. Where vacant possession simply you are returning to me in the state in which it was. If there were any alterations, we would have already settled on how the alterations are to be paid for. It's coming out of your rent. Am I paying for the alterations you want? Because it is my duty as landlord to keep the premises in a tenantable or in a state where a tenant can reasonably live. That is why landlords are also responsible for all repair works. So the pipe break, of course, practically you fix it and then tell your landlord that the main water pipe from ECG from Ghana water to the house broke, and because of the spillage, I had to fix it. But you will inform your landlord and he would pay for it because it's his responsibility. The same way he has a right to enter into the premises with your notice and with your consent. If there's the need to do any repair works, if there's any maintenance that has to be done. So once the tenancy has expired, once sufficient notice has been given, once the tenant has been reimbursed for the alterations done, I do not believe the tenant has any cause of action against the landlord.
Okay, all right. Thank you so much.
Hello.
Yes, hello.
Good evening.
Yes, hello.
Yes, Kwabena, and then thank you very much to Lawyers Diary Global. So my question is in two. The first one is, how many months notice should you give your tenants if you want to increase your rent? Your tenants.
Okay. Yeah.
And then secondly, the percentage increments that is allowed.
Okay, so I'll answer your. Hello, Eric.
Yes. Hi, Kwabena.
All right. So in answering your question, your agreement will normally state the period for which notices are to be given. Maybe 3 months, maybe a month, maybe a week. So it's dependent always on the tenancy you've entered into. And to give the time frame for giving tenancy. Normally, we are looking at reasonableness, and reasonably, depending on the nature and the length of the tenancy, maybe 3 months should be reasonable. Your notice should state the date in which you intend the new rate to begin, the old rate, and the date on which you want the tenant to continue paying the new, or to start paying the new rate. This is to allow the tenant, if he has any qualms with it, to go and see the principal rent officer. Now, the rent officers in every district have powers to assess the rent to be paid on the premises. There are certain things they look at. Of course, the reference I'm coming to make now is to the Rent Act, which was passed almost 4+ decades ago. So the test there may not be the test now. But in assessing rent payable and increases, if you are to go by that procedure, the rent officer is to look at the rate paid for premises within the vicinity. It's to look at things like the bank rate at the time. It's to look at the size of the premises and then it may even ask for expert advice, where expert advice will be the advice of a valuer. It will take all of this and then make an assessment of rent recoverable. However, tenancy agreements may also allow for percentage increases, especially when it comes to renewal. For example, you may have a tenancy that may state that the tenancy is renewable every 2 years. And at the point of renewal, a 5% increase in rent. This is something you agreed to at the onset of the tenancy. So if you decide to exercise the right of renewal, then you should know that it comes with the 5% increase in rent. So that is how rent renewals, the increase in rent is done. As for the period, it's always a reasonable period. 3 months is quite reasonable. It may be a month. It also depends on the nature of the tenancy. If it's a monthly tenancy, then of course, then the notice must be for a month. But if it is for one that is for an extended period of time, 2 years, 3 years, at least 3 months seems reasonable enough. I hope I've been able to answer you, Eric.
Yes, you have been able to answer. So in situation where your increments, we actually don't have a tenancy, okay, documents to say, and I normally pay annually, okay. So
Okay.
my last payment was for 2 years, and then that's about a month, 2 months to when my payment was. Then I was served a letter with an increment of 87%.
87.
Yes, 87%. So
Wow.
what should I do with that?
For something like that, especially where you do not have a tenancy and there are no clear-cut terms, I really would advise you go and see. I don't know which district you are, but there will always be a rent officer. Rent control still works. The misconception that it doesn't work is one that has to be cleared. Rent control still works. You can apply for an assessment. Your landlord will be served with a notice for the assessment. And together with the expert or whoever is called, an assessment of the rent payable will be done. And then it forms part of the record. If the landlord is not agreeable to the assessment made, he has the right to appeal. Of course, in doing all this, you must remember that it is his premises. You cannot compel him to rent out to you. So I would believe a bit of tact, mixture of the use of law and tact would help you. 87% increment, it's, for lack of a better word, unconscionable. But I believe you can negotiate. You can talk to your rent officer. You would have, the rent officers apply alternate means of settling disputes. There can be mediation, there can be conciliation, and you can actually get a fair result as between the two of you. And right after that, please execute a tenancy agreement.
That's the key word. Yeah.
Okay.
Please.
Very much. Thank you. Thank you.
All right. Is there any other question? Because we've exceeded our 1 hour. Now we are running into an hour and 20 minutes. The discussion is getting
statutory discussions.
Yeah, statutory discussion. So is there any other person that may want some clarifications? All right, so I've shared our social media handles on the screen. On Instagram, we are Lawyers Diary Global. On Facebook is the Lawyers Diary. And then on YouTube is Lawyers Diary. I would plead that we all like, follow, and then subscribe to our pages so that we get to see the upcoming events. Next week is going to be a very interesting week because one of my very own brothers, Stephen Obenda, will be on the show, and we'll be having discussions on the PNDC law 111. If a person dies without making a will, what happens to the properties? What are some of the major issues that evolve around dying without making a will? And then if something like that happens, what are the steps that we all need to undertake? Please subscribe to the YouTube page, especially because I've seen that even though the content is very good, subscription is very less. So please subscribe. All of you, please switch your phones and go and subscribe now.
Onesimus, before we leave, someone has asked a question. Prince asks what happens if the premises is rented out to two people. In such an instance, there's something known as the equities of priority, the first in time. It may be unfair, but the first person in time has higher equitable interest than you. Your interest is subsequent or subservient to his. So if the premises is rented out to Mr. Osei first, Mr. Osei makes some payments, he need not make all, but enough to ensure that there's an intention to create a relationship. And then later, the same landlord rents to Mr. Latte for even higher consideration. In your action, the court to look at the person who the premises was rented to first. There's always the first in time who has higher priority. I hope I have been able to answer your question, Prince.
Yes. Thank you, Governor.
All right.
All right. So thank you all. Thank you for your time. We are grateful and happy to have you. And then we also plead that please subscribe, follow, and like our pages. Every week in, week out, we are going to discuss topics of interest to everyone. We are sharing knowledge at little or no cost at all. So please be with us throughout this journey of making the law accessible and known to the ordinary Ghanaian. Thank you for your time today, and we are grateful, especially to Lawyer Mensah. Great presentation, great knowledge. I'm grateful to have you. Thank you.
Thank you for having me.
Sure. Thank you.
All right.
Bye.
Bye.
See you all next week.
Bye. Thank you.
Louise, subscribe to our YouTube page.
Thank
Yes,
you very
please, I will.
All right. Thank you all. Bye.
All right. Good night.
Father Lucy, thank you for joining us. And then Kenneth, Joy, Frank, thank you all.